Greetings, family. It's been a while not having a conversation. Yeah, but today I felt it appropriate that now let's have a conversation regarding, two related things. And firstly, the unlawful constitution of the Section 22 Committee of the CRL, and we are told it is a Section 22 Adhoc Committee for Christians. For Christians, yeah, it may be called so, but it doesn't mean it's correct. So we are going to have a conversation on that, as well as, what excited the CRL previously, when a legal opinion from Parliament was shared. Yeah, I saw even from their Facebook page, they spoke things in excitement to say, hey, legal opinion from Parliament says this and that, and they were happy. And this is not a strange thing. I also raised it in Parliament previous to engagements with the COCTA in the COCTA Portfolio Committee, chaired by Honorable Dr. Zweli Mkhize. And I was contending, for that position to say, Parliament guys, you got it wrong. And now I saw later on the CRL, they took that thing, ran with it, and with excitement. Now as a point of departure, let me first explain what a Section 22 committee is according to the CRL Act. According to the CRL Act, then from there, then I will show you, from the Act, and even from, documents from the CRL itself and from Parliament, to prove or to build a case on these issues that I'm talking about. Now, according to the CRL Rights Commission Act 2000, Act number 19 of 2002, first and foremost, if you don't have a copy of this act, you can go into Google, go to that search engine and type CRL Act and then PDF. Then you'll have a copy so that it's easy for you to follow what I'm saying, to verify as to the things I'm saying are so, or am I thumbsucking or so. Now, and then you can as well fact check me. I'll be mentioning some documents, and so you can fact check me by going to the sources of these documents to find out if is it as I say it, or not. Now, the first one that I will welcome my leader Simpiwe. I can see you. Thank you. So you go to Google, just Google there on your search, Google CRL Act. Yes, my leader, Mr. Judah, I see you. Thank you for joining. Now, Google for CRL Act, of 2002, so that you can fact check if the things I'm saying are like that or not. Now, like I said, our conversation will be about, the unlawful constitution of this Section 22 Adhoc Committee for Christians. And number two, to show you from the legal opinion from Parliament that the legal opinion from Parliament was wrong. I will show you from the very document where the error is. And unfortunately, the CRL was so excited to say, yay! Yeah, legal opinion says this. Who are you? Who are you? And we are beefed up. And there was excitement. And excitement with wrong things. Right? Now, my point of departure from the act itself of the CRL. Now, if you can scroll down to what is called the heading there, it's part 4 of the CRL Act. Part 4 of the CRL Act, the caption there says, operation of the commission. Meaning, if you want to know how the CRL operates, then that is the portion you go to find out how the CRL operates. Anything that has to do with how the CRL Commission operates is under that heading. Yes, other headings like first headings deal with, starting from the beginning. You find a heading there where now the first thing is your introduction of the act. Then you get part 2, which deals with the status, meaning the legal status, the objectives or objects, powers, and functions of the commission. And you have your part 3, which speaks of composition and membership of the commission. So things that have to do with how is the CRL composed and how the membership how to go about it. Now, where we are today, it has to do with the operation of the commission. How is the commission operating? Then after that, you have part 5 that deals with National Consultative Conference, as well as part 6 that deals with administration and, administrative and financial matters. Then you have your community councils, and you have miscellaneous, miscellaneous things. These are categories, headings that have to do with what the CRL is all about. So if you want to know what the CRL is all about, then you go through that act and then those sub-headings and so on. So my interest is on this part that deals with the operation of the commission, how the commission operates. Now, under the operations the operation of the committee, the first thing how deals with meetings, meaning how the meetings of the commission work or operate. Now you learn from there that the chairperson decides the when and where the commission meets and all those details about the meetings. And it speaks as well about the procedures, meaning how things are done procedurally in the commission. And we are told there that the commission determines its own procedure. And the other thing speaks of decisions. Now, how do the CRL commission arrive at decisions? How decisions are made in the CRL. You learn there that now decisions within the CRL, the commission must take decision in a consensus-seeking matter. So there must be consensus when decisions are made. So meaning it's not a one-person show. It's not a one-person show. A person, irrespective of their title, it doesn't matter whether they are chairperson or not. The Act tells us how the commission works. So on decisions that are made, if you look at it's a section 21 of the Act where it speaks of decisions, it speaks of consensus, And then if the section 21 and the B thereof says, if the commission fails to reach consensus on a question before the commission, a decision on the question can only validly be taken by a supporting vote. Now you see, then they'll take it for the vote. Now comes the part that I want us to look into, which deals with committees, how committees are formed within the CRL, and as well as we'll look into the delegation of power and so on. How does it work? Now, under committees, because we are talking about your section 22 ad hoc committee for Christians. Now, it's section 22 where committees are addressed to say how are committees formed in the CRL. Now, according to the Act, this is how committees are formed. In section 22, subsection 1, it says that the commission may, it doesn't say must. So it's may, meaning when necessity calls for committees to be there. The committee may do the following. A, meaning establish one or more committees consisting of members only or members and staff or other persons, then punctuation, comma, to assist the commission in the performance of its functions. And the B thereof of section 22, subsection 1 says, dissolve a committee at any time. So the first A of subsection 1 tells us how it is established. For a section 22 committee to be established, it is, section 22 committees, they can be more than one, because it says it can establish one or more committees consisting. Now, however, whether it's one or multiple of them. Now, here's a condition here. It says these committees, they are consisting of members only. And by members, it refers to commissioners. You remember those 11, if it's not 12 commissioners that the president has appointed. So a section 22 committee, can consist of members only, meaning commissioners only, can form a section 22 committee in terms of the Act. And then it says, or members and staff or other persons, then it puts a comma there. Meaning if it's not commissioners only or members only, alternatively, it can be members and staff or other persons, then it puts a comma. It's either it's commissioners only or it's commissioners and staff or other persons. Other persons means anyone outside the CRL commission can be part of a section 22 committee. So the categories in terms of the Act, there are two. And at all material times, a section 22 committee must have commissioners. If commissioners are not part of a section 22 committee, now in terms of the Act, then whatever that it is called, if there are no commissioners within what is called a section 22 committee, that thing is not a Section 22 committee in terms of the CRL Act. You may call it a Section 22 committee, but if there are no commissioners within that committee, then that is not a Section 22 committee as defined by the Act. So you can go there, reference check, fact check, and then I'll be coming back to this point. But as a way of introduction to show you what the Act is saying, then we'll deal with why, am I saying now this one that is called for Christians is unlawful. I'll then bring it. So let's start with what the Act is saying. So a properly constituted Section 22 committee, it must either have members only, meaning it must have commissioners only. Now, if you can see, commissioners who were appointed by the president forming some form of a committee and they call it a Section 22 committee, then you must know that's a lawful Section 22 committee. And if it's not made up of commissioners only, then alternatively, you must have a Section 22 committee that is, consisting of commissioners and staff or other persons. Now, if you have a Section 22 committee and you don't have commissioners in it and staff or other people, then you must know that is not a Section 22 committee in terms of the law, because in terms of the Act. So every time you are presented with a Section 22 committee of the CRL, look for who are the members. If you don't see members in that committee, you must know that that committee is not a lawful CRL Rights Commission committee. Even if, that so-called Section 22 committee can consist of staff members. By staff members, you are speaking to the operations led by the CEO, and currently the CEO is Dr. Mafadza. If you meet people from operations as well as other people who are outside the commission forming that type of a committee and they call it a Section 22 committee, know that that committee is not a Section 22 committee according to the CRL Act, Rights Commission Act 19 of 2002. Because guess what? According to the heading there, this is the operation of the commission. There's no way the commission can operate and people who are not part of the commission run the affairs of the commission that they don't belong to. That's why at all material times, because what will give a legitimacy to a Section 22 committee is when members, or commissioners are there, because these members are part of the operations of the commission. Now, whilst we are still at that point, we were dealing with subsection 1 of Section 22 of the CRL Act. Now, subsection 2 says the commission must determine, by the way, this is subsection 2 and it still falls under the committees. So subsection 2 is expanding further. Subsection 1 dealt with the establishment and as well as the dissolution, where in B speaks of dissolution, and it says in dissolving this committee, the dissolution of this committee can happen at any time. At any time, this section 22 can be dissolved. Even if it's lawfully, established, it can be dissolved. Now, subsection 2 then expands further on, then yes, it is established, it can be dissolved at any time, but now how will it work? That's where subsection 2 says, it says that the commission, now be careful of the words, the commission, if the section 22 committee is constituted properly according to subsection 1, then subsection 2 says, now the commission must determine the functions of a committee, meaning that committee will receive marching orders from the commission. So it is the commission that will determine, and the word says, it's a must. That committee doesn't have a choice, but it must determine, the commission must determine the function of that committee. It is the commission that must determine the function of that committee. And that makes sense because it's part of the operations of the commission, you see. So there's nothing wrong with the CRL commission, with the commission, determining the function of, a section 22 committee. The CRL commission, the commission must indeed determine, the function of a section 22 committee. And secondly, the commission must appoint a member of a committee as the chairperson of the committee. Now, again, it is a must for the CRL commission to appoint a member of whoever, was established in subsection 1. It is a must for the commission, to appoint, a member of a committee as the chairperson of that section 22 committee. So the onus is on the CRL, firstly, to determine the functions of that committee. Secondly, the onus is on the CRL to appoint a member, one of those members to be a chairperson of the commission. And number 3, the CRL commission can remove a member of of a committee at any time. It can remove any member of that section 22 committee at any time. So the CRL is empowered by the Act to remove anybody from a section 22 committee at any time, even 3 minutes from now, or a second from now, or a nanosecond from now. They are empowered by this law to do so. And number 4, the commission may determine a committee's procedure. It may determine that committee's procedure. At least there's a leeway even on removing, meaning when it's necessary, the commission may remove a person. When it's necessary, the commission may determine even the procedure. So when the commission determines the procedure of a Section 22, when the commission removes a person, don't have a problem with that because they are empowered to do so. But now the things that are a must, that they are obligated to do, is to ensure that a Section 22 has a chairperson, and that chairperson is a chairperson that was determined by the commission, and as well as the commission must also determine the functions. And by the way, for this, functions to happen, it will mean a decision would have been, arrived at. For the commission to determine what is the function of a Section 22, for the commission to make sure that who is a chairperson, or whether to decide in removing a member or determining the procedure, then this committee, would have, emanated or came from decisions that were made by the commission. It means the CRL commission will take a decision by consensus, and by a vote, to say this Section 22 committee, the function of the Section 22 committee is this. And secondly, by consensus, they will say, we are appointing so and so as the chairperson, meaning the 11, or the 12 that the president has appointed. They are the ones to say, guys, the president has appointed us, we need a Section 22 committee. So firstly, what will be the function of that Section 22 committee? Secondly, who will be the chairperson and then of that Section 22 committee? And then at any given time, they are like, no, we can remove so and so from this Section 22 committee, as well as, no, we can determine as well the procedure as to how will this committee work and things like that. So this is the powers, that the CRL has on that committee. They have the power to establish it as well as to determine how it works. And then there's an aspect now, we have dealt with issues of a committee and so on, that we need to look at as well, which is the Section 23. Section 22 has shown us how is that committee established and how is it to function and all those details. Now, Section 23, subsection 1, the heading there says delegation of powers and assignment of duties, meaning how the CRL delegates powers, as well as, how the CRL assign duties. By the way, we are talking to the operations of the CRL. So under the operations of the CRL, we've dealt with how they establish the committee and how they, deal with the committee. But here, how does the commission deal with the aspect of delegation of powers as well as assign duties? That is Section 23, subsection 1 says the commission may delegate any of the commission's power. The commission, those 12 or the 11, they may delegate any of their power or the commission's power to a member of the commission. They can decide in their meeting to say, we want a particular commissioner to handle a particular work. And then they have a consensus, then that, individual commissioner will be given the power to do so. Or they can have a consensus in their meeting to delegate, the commission's power to a member of the commission's staff. They can say, okay, now let somebody from operations under the CEO, Dr. Mafadza, the operations team, the CRL, the commission can decide, the 12 can decide to say, no, we will delegate this responsibility to a functionary within operations to say, do 1, 2, 3 for us. They can do so if they deem it fit. And thirdly, what the commission can do in delegating its powers, they can delegate any of the commission's powers to a committee of the commission. They can delegate their power to a committee of the commission. Now remember, we cannot speculate or assume what that committee of a commission is, because Section 22 has already told us about committees. And check that word there. It says in Roman figure 3 there, it says it's a committee of the commission. So those words, the word of is possessive in nature. It tells you about ownership, meaning who owns or who's responsible, for this committee. So it speaks of a committee of the commission. What does that say? It says to us, because if we are to look and find out or ask ourselves, what is a committee of the commission? We must go to the Act, and the Act will tell us what is a committee of the commission. And within the Act, the only place where we are told of a committee of the commission, or where a committee of the commission is described, is in Section 22, because Section 22 speaks of speaks of committees, and committees that are part of the operations of the commission. So a Section 22 committee is a committee of the CRL. It's a committee of the CRL. That's why the CRL can delegate its power to that committee. And that's why it's crucial, even in terms of the Act, that members of the commission must be there, because they will give legitimacy to that committee. Without the members, that thing that is called the Section 22 has no legal standing and legitimacy in terms of the Act, because of how it's constituted. Right? Now, subsection, alphabet, subsection 1A was the one that spoke about the delegation of powers, meaning that the CRL commission may delegate its power to either a commissioner, which is a member of the commission, either a staff at operations, or either a committee. And check there, because of with the first two are individuals. But when it gets to the committee, the delegated power is not to an individual, but to a committee. When it's a commissioner, delegated power can be given to a commissioner to act on behalf of the commission. And then secondly, delegated power can be given to a member of the staff, of the CRL commission staff, to act on behalf of the commission. And thirdly, then delegated power, can be given to a committee of the commission. And a committee is a collective of that committee that was formed according to Section 22 of the CRL Act. Now, the B says the commission may assign performance of any of the commission's duties to any such member, staff member, or the committee. Now, the commission may delegate, or may assign, either a commissioner, it may assign the staff from the operations team, or a committee to perform the duties of the CRL commission. Now, subsection 2 says that a delegation or assignment in terms of subsection 1 is subject to such conditions and directions as the commission may impose. Whether it's one commissioner delegated with assignment and power, whether it is the staff member at operations delegated with power and given assignment, whether is the member of the commission, the committee of the commission. Now, either of the three, is subject in them carrying out their delegated powers, in them carrying out the assignment or performing the duties of the commission. They are to do that subject to such conditions and directions as the commission may impose. So when the commission says we are imposing this direction, follow this direction. Now they are calling it terms of reference. Follow these terms of reference. So the terms of reference are those things that are imposed, because this is an expectation that the commission is having on whether that individual commissioner, it's an expectation that they're expecting from a member, a staff, or this is something they're expecting from a committee. So whatever that they do, there's no freestyle, but it's subject, whatever that they do, it's subject, to such conditions and direction as the commission may impose. And the B of subsection 2 says, does not divest the commission of responsibility for the exercise of the power or the performance, of the duty. So that thing doesn't mean freestyle. Do it, do as you like. The CRL is still responsible. Is still responsible, even if you operate with delegated authority. With delegated authority, the CRL is still responsible. Still responsible. That's why it says that the B there tells you, that you cannot do this, and therefore you cannot, sell off assets, investment, or business units, or do whatever as you like. So provision is there within the Act. There are limits, there are boundaries, and the boundaries are set by the Act. Now, the other thing that is interesting is subsection 3 of the Act. It says the commission may confirm. It may confirm. The commission may confirm, vary, or revoke any decision taken in consequence of a delegation or assignment, but no variation or revocation of a decision may detract from any rights that may have accrued as a result of the decision. The only thing that will keep them from confirming, varying, or revoking is that, it may, by no variation, but no variation or revocation of a decision may detract from any rights. It must not tamper with any rights that may have accrued as a result of a decision. Yeah, but now the interesting part there, the Act tells us that the Commission may confirm, meaning the 12 can confirm, can agree to say, yes, we accept what the committee came up with, or we may accept what a commissioner came up with. They may confirm and say, yes, we accept what the staff member came up with. They may also vary, meaning the committee may come up with something, but the 12 may vary it to say, on point this and point that, things are not like that. On here and there, no, it can't be. That is to vary. Yes, here and there we agree, but here and there we don't agree. They can vary. As well as revoke any decision. They can revoke any decision, meaning a Section 22 committee can go through an exercise of finding out and doing their work and doing everything, finding out, researching, and do all these things. And at the end of the day, when the decision doesn't look like what is expected by the commission can revoke that thing. They can rubbish that thing, put it in a dustbin, and say, no ways, we are not buying into this thing. Now, these things that I've highlighted, that's how the commission operates in terms of the Act. So they are there in the Act, download it, and CRL Act, of 2002, PDF, then so that you can verify what I'm saying for yourself from the Act itself. Now, why am I saying that this Section 22 ad hoc committee for Christians that has been established by the CRL, that it is unlawfully, in bold letters, in bold and capital letters, it is unlawfully constituted. I've just explained, from the Act, how does a proper Section 22 committee of the CRL look like. Now, why am I saying it's unlawfully constituted? Now, this is what has happened in the establishment of this Section 22 ad hoc committee for Christians was established. The first thing, now you can check it, you can fact check it, you can go to the CRL Commission's website and go to media statements so that you fact check me. Go to media statements. There's a tab there in the CRL Commission website. Go to media statements. And when you arrive there, look for a document, because that's the first one that I'm referencing. A media statement there dated the 6th of October 2025. Yeah, just note that date. Yeah, when you arrive there, there's a document dated the 6th of October 2025. And that's if they are honest enough to keep and not tamper with those things. You should get it. If it's not there, then we have an issue. It should be there because it's been there. It's been there. Now, you go to a media statement dated the 6th of October 2025. So what I'm going to read, I'm quoting from that media statement on the 6th of October 2025. Now, it reads as follows. Now, that deals with the foundation on how that Section 22 Adhoc Committee for Christians was established. We want to see that was it lawfully constituted? So how do we arrive at that conclusion? We are following how it was established. Now, this is how it was established. I'm starting first with the October 6, 2025, and I'm reading from a CRL Right Media Statement document, an extract from there. You can read it and read it as a whole, and fact check me on it. It says, the findings of this investigation, meaning commercialization of religion and abuse of people's belief systems, were subsequently presented to the Portfolio Committee on Corporate Governance and Traditional Affairs, which is COGTA, which held discussions with diverse array of religious leaders, resulting in a set of significant recommendations in 2018. Now, they are speaking to a report from the COGTA Portfolio Committee dated the 14th of February 2018. They are saying, now these are the findings, that COGTA, held after discussing with the array of diverse religious leaders. Then it says, the committee noted the reported abuses in the religious sector and thus recommends the following. A charter, now you must mind that word, recommends the following: a charter for self-regulation and code of conduct for the sector, which should be recognized by legislation. And they are saying, in response to these recommendations from COGTA Portfolio Committee regarding self-regulation in the Christian sector, the Commission invoked Section 22 of the CRL Rights Commission Act to establish a Section 22 committee. They are saying the reason they started a Section 22 committee for Christians was on the basis of the report that was said in February 14 of 2018. Their decision is based on that February 14 document from COGTA committee, which has thus been constituted and comprises of Christian leaders from various umbrella organizations, including inter alia, mainline, independent, charismatic, and Pentecostal churches. Now, they are saying they've established a committee, a Section 22 committee, which includes people from umbrella bodies, and they are quoting, they are saying from mainline church, independent church, charismatic, and Pentecostal churches. They are saying the reason they established that committee was in response to February 14 recommendation by COGTA, right? That's the reason. That's reason number one. And remember the reasons at COGTA, although here, this is not two things. COGTA spoke of more than two things. More than two things. So it's just these two which now speak to, the involvement of, other people and so on. But COCTA also spoke to government entities in their recommendations that they should tighten, their legal responsibilities and so forth, right? Now, that's what CRL is saying. It says, you see a Section 22 Adhoc Committee for Christians. The reason it's in place is because we did it, so that, we can give effect to 14 February 18 report from Parliament, or recommendations. Let me not say report, but recommendations from the COCTA Portfolio Committee. Now, that's the first thing we must note as to the reason why the CRL started this kind of a committee. Now, here's another interesting one. Now, this one, you will get it from a media statement from the CRL Commission's website that is dated the 22nd of April 2025. So when you go to the CRL website media statement, go to this document dated the 22nd of April 2025. When you get there, then you will see these words that I'm citing so that you can fact check me on it. Now I'm opening quote. By the way, I'm explaining the CRL's logic or rationale for appointing the Section 22 Ad Hoc Committee for Christians as to how did they arrive at that decision. They said reason number one was in response to February 14, 2018 recommendations from COCTA Portfolio Committee. That's their first reason. Now I'm giving you the second one. Now that is dated April 22nd, 2025. It says, today, the CRL Rights Commission held a press conference at which it presented a framework to establish a peer review council. They presented a framework to establish a peer review council. Why? To give effect to this process. The commission, in line with its mandate stated in Section 22(1)(a) of the CRL Act 19 of 2002, may establish one or more committees consisting of members only or members and staff. Now, CRL there has put a comma after the word staff. You go to the original act, you won't meet a comma after the word staff. And then all the other persons, then another comma to assist it in the performance of its function. Now you'll see from there's a comma after the word staff. You go to the original act, you will not see a comma after the word staff. After the word staff. And in both scenarios, firstly, they say that the reason you see a Section 22 committee for Christians, reason number one was in response to February 14, 2018 recommendations from COCTA Portfolio Committee. And they are saying again, they are presented a framework to establish a peer review council. Mind you, the February 14 of 2018 recommendation by COGTA Portfolio Committee. COGTA Portfolio Committee never told the CRL Commission to start or to establish a peer review council. So this peer review council issue is the idea of the CRL Commission. It is not a recommendation by the COGTA Portfolio Committee. So even if the CRL was like, okay, we want to be, the good students of COGTA Portfolio Committee, they did not follow what COGTA recommendations said they must do to the letter. Something that they've omitted in their October 6, as well as, other communication, was to say, COGTA said to CRL Commission, they should organize a national consultative conference so that the people in the sector can design and develop a charter for themselves. Secondly, design a code of conduct for themselves. So the CRL has no business, trying to, whether come up with a charter for, what do they call it? This charter that the committee spoke about, a charter of self-regulation. They have no business, coming up with a charter of self-regulation as well as the code of conduct. That thing has been entrusted, has been recommended to the sector. What the CRL was recommended to do was to organize a national consultative conference, because it's part of the things that they are supposed to do in terms of the CRL Act. So we must get that right. So they did not follow the instruction. And I heard last time Umam Kaluva was saying, no, but we had, that NCC and so on. Now, because of that is not accurate. That's not accurate. That's not truthful. Yes, the NCC did take place, but it did not happen, as per the recommendation, how it happened. What happened, is that on the 13th, a week before that NCC took place, then there was, a gathering of the sector, the religious sector at Rema on the 13th of February, 2018. And there, they did not like the conclusion of the sector. And therefore, that NCC that she was speaking to when she was called into account, even in parliament, you see, was the following week, where people in the sector, including ourselves, we were barred from attending that thing. And then even the delegation that we chose in the interim at Rema, they were told that no, you can't come. This is not relevant for you. Yeah, according to the report that I've got from one of the leaders who was part of that task team, that we gave the responsibility to facilitate these things, according to that Rema incident in 2019. So they did not follow the letter of that. So to say, no, we did have an NCC, so that's misleading. It's misleading. It's inaccurate. It's inaccurate. It's inaccurate. So a full report must be given on that. And then this is some of the things that we want to deal with. Yeah, because don't just believe without proving these things. That's why I'm saying, fact check what I'm saying, if what I'm saying is like that or not. Because it's based on evidence, what I'm saying. Fact check me. And if I missed anything, prove me wrong with these references to say, no, man, there, it's not like that, it's like this and that. Yeah. So I'm ready to be challenged at that level with evidence. I'm not speaking from memory. That's why I'm reading. I keep on taking my head down so that I read. So you can check it there. So on aspect number 1 is that firstly, they were saying the committee is there in response to that February 14. Secondly, they are saying they've established a peer review council. COCTA did not say they should establish a peer review council. So the idea of peer review council has always been the CRL Act, the CRL Commission's idea, never a recommendation from Parliament or COCTA. It's always been an idea of the CRL. Yeah. And then, truly speaking, the reason why the 2017 report, of the CRL was rejected, it was for the very reason of this peer review council. That's why the committee was clear to say the sector must establish a charter, not council. The both words may start with alphabet C, but they are not the same thing. A charter is a document. A council is a body of people. So they were not told to start any council or a peer review council. This has always been the idea of the CRL. So I thought I should clear that. Now, so I said they've put a comma in terms of the quotation of the act. So in putting a comma after the word staff, they created category 3. They were creative with the act. Now, they amended in the legal language, they amended the act so that they create for themselves a version of a section 22 that is unlawful, a version of the section 22 that is not in line with the CRL Act. So this section 22 Adhoc Committee for Christian is not in alignment with, a lawful section 22 committee in terms of the act. Yeah. Now, the CRL Commission, then its objectives in forming this, I call it a bogus Section 22 Committee for Christians. This is what happened. They say that the Section 22 Committee, these are terms of reference now. Remember, they must determine the function and appoint a chairperson. So this speaks, the first part was dealing with the invocation of Section 22, 1A. But now what I'm going to read, speaks to your subsection 2 of Section 22. It says, the Section 22 committee shall come up with mechanisms to deal with issues in the religious sector, especially protecting the rights of the Christian believer, while ensuring that the religious freedom is maintained in line with the Constitution. Remember, subsection 2 spoke of the commission must determine the function. So function 1 of this ad hoc committee for Christians is to come up with mechanisms to deal with issues in the religious sector, promoting and protect the rights of the Christian believer. And secondly, to undertake provincial and national consultations with religious, in the sector. This committee is to, undertake provincial and national consultations with religious leaders in the sector. And then thirdly, develop strategies to deal with and curb spiritual transgressions. Thirdly, number 4, make recommendations for legal, you see, that big word. Make recommendations for a legal and or legislative framework to promote peer review mechanisms. You see? in the religious sector. The other thing, encourage collaborative and cooperative relationship within the Christian religious sector. Conduct extensive research to assess the scale and the impact of abuse of people's beliefs, harmful religious practices, and things like that. Now, this you will find from a document, again, you'll find it on 22 April 2025 document, as well as the following one says, for that reason, its mandate is to facilitate broad consultations and conduct dialogues within 12 months that would result. You see, we are told the dialogues must result in mechanisms and strategies to identify and address challenges in the sector, halt the harmful practices and some religious leaders within harmful practices of some religious leaders and their congregations exhibited by certain leaders, thereby ensuring an effective implementation of the portfolio committee's recommendations regarding self-regulation of Christians. So they are telling us as the sector, you see, they are giving the Section 22 committee marching orders to say, Siantuma, hambani nwenza so. Go and do this. By the way, the functions in terms, if it's a Section 22 committee, the functions of that committee are determined by the CRL commission. It's a must for this committee to do what the commission tells them to do in terms of the act. Now, the other point, here's an interesting one, which speaks to the commission's participation. Now you will find in the October as well, 6 of 2025, there are these words that, the chairperson said it, and it's in that October 6 that you will find there. Somewhere there, down there in that document, it says, the CRL Rights Commission will not be part of this committee. It says the CRL Rights Commission will not be part of the committee except for the staff members who will provide administrative support. Is the chairperson who told us, it's there in black and white from that media statement, from the CRL website. She said it straight to say, the commissioners, the members that are required by Section 22 of the Act will not be part of this committee. They will not be part of this committee. They are calling it a Section 22 committee. And they are saying commissioners will not be part of that committee. And we have learned that a properly constituted Section 22 committee will include, it's a must, it will include commissioners. If there are no commissioners in a Section 22 committee, the letter of the law would have not been followed. So if the chairperson says the CRL Rights Commission, meaning those 12 that the president has appointed as commissioners of the CRL Commission, if they are not part, she said they will not be part of this committee. Now, once you don't have commissioners as part of this committee, that committee is not illegal. It's unlawful. Section 22 committee. It's unlawful. Now, the unlawfulness of that committee, number one, Okay, before I get there to the number ones, let me exhaust this. Then I will summarize this because I'm speaking to two things. I wanted to show you the unlawfulness of this Section 22 committee. So as you attend to this, you must know that now you'll be availing yourself to a committee that is unlawful. An unlawful committee will be organizing things, consultations nationwide. It started, provincially. And we went there on the 21st of April to make a presentation on behalf of the Council of Charismatic Churches, COCC. We went there to make submission. And one of the things we dealt with to address the leaders there was to tell them that first and foremost, they must understand that they are unlawfully constituted. In terms of the act was breached to accommodate them. So you have leaders who are religious leaders, who are pastors, some highly educated, some with prestige, who are there, who've been placed there, and they celebrated to be part of a committee that is unlawfully constituted. They are unlawful. They are unlawfully there. Unlawfully there. I have shown you, firstly, from the act, that commissioners are not there. And even the chairperson said it straight that commissioners will not be part of that. So on that point, when she said commissioners will not be part of this, all those leaders who were there would have just dropped their resignation on that spot. They could not have allowed themselves to be part of a committee that is unlawfully constituted according to the act, but they took the responsibility of being part of a committee that is unlawfully constituted. So you'll be faced by a committee of people that are unlawfully constituted, and then they are trying to solve things, legally. They must come up with legal framework for you. They are unlawful. And it's like, for lack of a better words, Tsotsi is trying to preach law, to another Tsotsi. I know I'm being drastic, I'll be in trouble with that, but I have to bring the message across. To say Tsotsi is trying to legalize Tsotsi. Tsotsi, why? Because you are Tsotsi, because you are not acting according to the law, but you want to enforce the law. How does an unlawful person enforce the law? Because you must be lawfully constituted to deal with legal processes. That's what it is. I know I'll be in trouble, but it's there in black and white, so I can say it confidently. It's there. You can fact check me. Yeah. So they are there. They've accepted a responsibility that they've been appointed unlawfully so. They embraced it with, hands, open wide hands, educated. People who can read, some with PhDs, some they've been running municipalities, some, historically they've been there, like the Mazibukus, they've been there around. But how did they fail to see that a properly constituted Section 22 committee includes commissioners? If you don't have commissioners in a Section 22 committee, that committee is unlawfully constituted. That's that. Now, the other thing that I want to deal with is the parliament. I'll be dealing with the parliament. Oh, before I get there, now we've learned. I will just run fast here because this is the part I dealt with in the beginning to show you how does a legally constituted Section 22 committee gets, constituted, how to do it legally. So I started by showing you how a legally recognized Section 22 looks like. And now I've shown you this unlawful one, that how was it unlawfully? It was unlawful because it did not follow the letter of the act. And secondly, unlawfully because it was put there under false pretenses. The pretense that says Parliament said this without following fully, in the name of the Parliament, and therefore something is done in the name of the Parliament that Parliament never told them to do. Even if we were to follow that for February 14, 2018, the February 14, 2018, it says they should organize a national consultative conference. Did they do that? No. The answer is no. They didn't do it because even that thing was said it must include every people. It was so prescriptive to say what exactly to do. So if it's Parliament, it must look like what Parliament said. If it doesn't look like it, it's not it. So this creativity that they came up with, unfortunately. Now I'm running quick on that part of how does a legal Section 22 look like. Now a legal Section 22 committee looks like this. It's either commissioners only or commissioners and staff or other persons. So it's only two categories according to the Act. Now, if you can see a Section 22 and you see commissioners in it, that one, it's a lawful one. But when commissioners are not there, it's unlawful. It's unlawful. It's unlawful according to the Act. And then secondly, either members only, or members end. And then we spoke to that aspect to say a committee, a Section 22 committee, it's a committee of the CRL. It's a committee of the CRL. It belongs to the CRL. One of the things that, that the leaders in that ad hoc committee for Christians are saying they are an independent, body away from the CRL. There's nothing in the Act that says a Section 22 committee is an independent committee. A properly legal Section 22 committee is a Section 22 committee of the CRL. A Section 22 committee is not independent from the CRL. This is one of those things I spoke to on the 21st of April to tell those leaders to their face, to say, guys, in their introduction, they said, no, we are an independent and then independent from the CRL. I told them, that's wrong. There's nothing like that. And I use even a street word to say, by using a street word, you are fronting for the CRL. As we stand here, we are appearing before the CRL Commission because a Section 22 committee is a committee of the Commission. So we were appearing before a bogus CRL Rights Commission. If it's independent, there's no provision in the Act that says a Section 22 committee is independent from the CRL. And if it's independent from the CRL, if we follow that logic, then why did it take the CRL to appoint a chairperson? Why did it take the CRL to determine the functions of that? Why those terms of references came from the CRL itself? If it's independent. So that's a front. That's a front. So yabona manje, it's a problem. It's unlawful and now it's criminal because you are projecting a face. You are saying people are independent when the law says they are not independent if they are to own that Section 22 committee. So when they come and travel and come to provinces, you must understand that they are unlawfully there. The act that does not cater for such a committee to be there and be interviewing you in the sector as religious sector. They have no business interviewing you, consulting you, and so on, because they must deal with the legalities first of them being there. I understand SACD has laid, a court and so on. A court has not pronounced, but what the court does, there's nothing about the court that is not available in the laws. The law will not change. This act will not change. What is written here will not change. And what the commission, those documents in the CRL, that evidence and so on of what this, nothing will change. It's here in black and white. Because the courts are subject to this. This is what Parliament arrived at. The business of the courts is to interpret the laws, you see. Not to rewrite the laws. Rewriting the laws, amending the laws is the responsibility of Parliament. That's why now when courts arrive at certain things that are unconstitutional, that they have issues, they refer those things back to Parliament so that Parliament can amend them and things like that. But writing laws and so on is the field. Is the field of Parliament. Yeah. Yeah. They'll have to rewrite this. Then I'll understand. But with what is available now, no. No. Yeah, because you just need to appreciate basic English to understand these things. Yeah, I do understand those interpretation of statutes and so on within legal framework and so on, but it's basic English because the principle there says, if the plain text says this, we cannot define things away from the clarity that we see from language. So the first point of departure is what is it that is written there and what does it mean before we can go extraordinary. Yeah. Right? Now, the other thing, I have spoken to say it's two categories. If you don't have a commissioners in a so-called Section 22 committee, that thing is unlawful. Secondly, now you either have, commissioners only or commissioners and staff or other people to legitimize it. So when they are coming there, those are unlawful people will be coming to you, interviewing you, empowered, by Umam Togo Kalova and company. We don't know how many of the commissioners endorse this unlawful exercise. I don't know how many of them came to this. That's why one of the submissions we've made to Parliament was to say we need all commissioners to be present at COPTA there so that they can individually account for this unlawful thing. That how did they arrive at this unlawful thing? And now spending taxpayers' money with this unlawful thing. Right? Okay? It's not anger. You can reference there. Check it for yourself. If we are to do it, we must do it right and legally so. Right? And I've spoken to the operations of the commission that Section 22 is part of the operations of the commission. So people who are independent from the commission, how do they see themselves in the operations of the commission? If we are an independent body away from the commission, how do we run the affairs of the commission? It's like a person who's not a member of your house running the affairs of your house. What's that? It can't be. It can't be. It's legally impossible. And the other thing, it's been the commission that has determined their functions. So if the commission determine their functions, how are they independent? So it's fronting. So the Malumas and others, they are just fronting for the CRL in the name of, that's deception. They are deceiving the nation. Let me put it strongly. That's deception. Because you give people an impression that this body of people are independent when you know very well they are not. That's why now and then they must report to the commission of 1, 2, 3. If you ask them questions, some of them, they are clueless. They were there saying, hey, we are learning things. We see what you are coming from. Now, even basic things, they don't even understand. They didn't read even what, all that they hear is sound bites from, media, and things from, but to really go into the trouble of going through these things, I don't think so. Because they've proven, I've tested, been there with them, bringing up things to them. They can't even see, the wrong. They are saying, let's brush it out, as long as let's go with the motions. We are not going with the motions here. We must be lawful because of this thing is done in the name of a Chapter 9 institution, which must promote constitutional democracy, which is based on the rule of law. So if we are not governed by the law in, how we do things that pertains to the law, how does it work? We must be 100% to the T. Right? Now, the other thing is that COGTA never said they should establish a peer review council. They never said it. The peer review council is an idea from the CRL. It's not from COGTA. Now, here's a problem now that we are facing, from legal service as I wrap up. Let me deal with legal service. Now, Parliament Legal Services made mistakes. I remember when we were in that meeting, I think it's February meeting at COGTA there, I raised it up to say to the portfolio committee, to say, they did not follow the letter of the word, or the letter of the law. And now this is what we've been saying. Then COGTA looked for legal opinion from Parliament Legal Services. Then they produced a document. And I remember on that day, Honorable Mkhize was excited, even saying as he was starting with the committee to say, no, we got input from the legal service, and they are saying to us, there's nothing untoward in how this Section 22 committee is there in the first place. And then, so based on that, conclusion from legal services, so there's nothing wrong with the Section 22 committee. Now, on the follow-up meeting, in March, I came back, to challenge that position that the chairperson spoke to by pointing the error from the legal services. Now, the error of legal services is from the very document. If you can find that document, you will see the things I'm talking about. Yeah, that's why we need to be diligent and, check these things. Now, if you go to that thing, that document from legal services, by the way, it was written and designed by Dr. Barbara Lutz, the acting senior parliamentary legal advisor, and Mr. Lehotlo Mushokwa from parliamentary legal advisor, and is dated the 9th of December 2025. The 9th of December 2025. Now, this is what I will be dealing with now. That this document is flawed. There's a problem because the writers of this document and legal service, they didn't do due diligence. They did not do a proper work here of checking and analyzing. You see these things of sound bites, and you just do things and not carefully read, especially legal material. Legal material demands, that we be sober and really be careful. Now, there's something in that legal document. The first thing I'm going to deal with is under the heading background. And then if you can look under that heading background of that legal opinion, paragraph 4, line 3, it says the report, that is COGTA Portfolio Committee report of 14 February 2018. Now that's in parentheses just to emphasize the word report. Recommended inter alia that there is a need for the establishment of a peer review council. Now, Legal Service, in their advice to COGTA Portfolio Committee, they are telling COGTA Portfolio Committee that their report recommended inter alia that there is a need for the establishment of a peer review council. You go to the report of 14 February 2018 from COGTA. There's no way in that report where COGTA said there's a need for an establishment of a peer review council. That is error number 1. That's a lie. Let me put it strongly again. That's a lie number 1 from Legal Services. From Legal Services. That's a lie number 1. COGTA never said there's a need for the establishment of a peer review council. This idea of a need for an establishment of a peer review council is the language of the CRL. Go to that report, and if you find in that report of 14 February 2018 from your PMG, your Parliamentary Monitoring Group, type in 2018 there, look for February 14, look for this report. If you can find a place where they say there's a need for the establishment of a peer review, council from their report, I'll come here in public and repent as strongly as I'm denying it, that they never said it. I'll come here and, to say, I was blind to that, but I'm telling you, it's not there. COGTA never said it. But Legal Service, they said to the committee, one thing I also stated to the committee, to say, guys, do your job, read your own minutes and your own reports. Don't rely on second-hand information so that you don't commit mistakes. If they done, as a committee, their homework, they would have seen this error from that legal opinion. They just took it and say, it's from legal opinion. They know what they're talking about. Therefore, let's tell the leaders, this is from legal opinion. So that Section 22 Committee for Christians is okay. It's not okay. Because of, it never said there's a need for a peer review council. And then, what the committee said, it says, it never said it recommends for a peer review council. And under the heading, the second heading, so that's strike number 1 from heading 1, from the background, that aspect of a peer review council, it was never a recommendation of COGTA Portfolio Committee. Secondly, under the heading, the legal status of the Section 22 committee process, now there is paragraph 25, line number 1. This is line number 1 of paragraph 25 of legal opinion. It says there is nothing to suggest that its establishment is irregular or unlawful. Legal Service says in the formation of that Section 22 committee, there's nothing irregular about that, and there's nothing unlawful about that. Now, There are four things that speaks to irregularity and unlawfulness. The first unlawfulness has to do with misquoting Section 22 of the CRL Act. And then legal services, they missed to read the letter, of that provision of the Section 22 committee. And then as well as, now, if you want to prove it, you can even prove it from their own document. If you can look at paragraph 6, that is how CRL quoted Section 22 committee. And paragraph 16, that's how legal services quoted the same act. Provision of the act. You go to paragraph 6 and 16 of that legal, services opinion, you will see there's discrepancy. The first, in paragraph 6, they typed what looked exactly like what how the CRL wrote it. And paragraph 16 speaks to, they wrote it like it looks like in the act. So they are arguing, against themselves in their document. Paragraph 6 and 16, you will see in their citation of Section 22 of the CRL Act, you will see there's the word comma, the comma, punctuation comma, you will see it in paragraph 6, and of which I believe was a copy and paste, of the CRL document. Yeah, I will be proven wrong on that. But how could they make the same mistake as the CRL had they not just copied and pasted, on their opinion? But in 16, they write it accurately. There's no comma after the word staff on that provision of Section 22, 1A. Right? So a careful reading, you will see. So if the act doesn't put a comma after the word staff and the CRL put a comma, isn't that irregular and unlawful? Unlawful in the sense that, it's an amendment of the law. Does the CRL have the power to amend the law? Has the Constitution given CRL the power to amend the law? Even if it's a punctuation, that's amendment because it changes the meaning of that, right? So CRL does not have legislative powers to amend the law. They've amended the law and created a Section 22 out of their own amendment of the law. All right. I've shown you that the first thing was legal service spoke to establishment of a peer review council, and they were wrong in their background. Secondly, I'm showing you that CRL amended the law, and legal service says it's not irregular for the CRL to amend the law. Is it not irregular? Does the CRL has the power to amend the law, or Parliament? They must answer for that, and something that even Honorable Zweli must call them, in our next meeting. We want them to take them, through this so that they account for this. And the third thing, if you look at paragraph 26, they are not sure, and their uses the words like it appears as if the Section 22 committee was established with due regard to the functions of the CRL Commission as set out in Section 5 of the CRL Act. Now, here's something in Section 5.2h. It says, it states that the CRL Commission should engage in any lawful activity, and now CRL must be engaged in lawful activity. They are saying there's nothing unlawful. So how do you call it a lawful activity when they amend the law? Is it lawful? How is it a lawful activity when people who are not legally placed, go about using state money to consult provincially and nationally? People who are unlawfully constituted, they are using state money to, do the so-called lawful exercise. And there's clarity there to say CRL must not participate in, in activities that are not lawful. It's not lawful for that Section 22 to do what they are doing. They are wrongly constituted under false premise, So how is it not irregular and unlawful? The other thing is that COPTA Portfolio Committee report and deliberations of it did not recommend the CR to undertake the exercise of establishing a Section 22 committee to this effect. It stated that it should organize an NCC. The report says they should organize an NCC so that the sector itself. How is it not irregular when Parliament says, guys, you are empowered by the Act to organize a national consultative conference so that people in the sector can, determine, they can develop a charter for themselves and a code of conduct for themselves? How is it not irregular? Because it was not followed to the letter. How is it not? So what business do they have with the Section 22 committees? All they were needed to do was National Consultative Conference, and then we design a charter for ourselves and a code of conduct for ourselves. End of business. How is it not irregular? Again, the Speaker of Parliament said that February 14 report has lapsed and it was not revived again. So it's as good as non-existent. And this is something at least positive that legal service said to them to say, this one, that February 14 thing. So if they are placed into the committee on a wrong premise of a non-existent, a dissolved position from Parliament, how do they take up a matter that has died in December of 2018 in terms of Parliament processes? You have seen with, the Section 89 committee thing, what happens when processes, are not followed. Processes must be followed before we can act and spend the state's money as good stewards. So it is on those grounds that I'm saying legal service got it wrong. They said to COCTA Portfolio Committee to say, hey, you COCTA, you said these people can, there's a need for a peer review council. COCTA never said that. They were wrong. Legal services was wrong on that score because of COCTA never said that. Secondly, they said, okay, no, there's nothing irregular. How is it not irregular when CRL amend the law to accommodate a group of people to do a function of the CRL? And here's another one, the aspect of independence, that they are independent and so on. How is it not irregular that these people are independent when the Act doesn't say they are independent? That's irregular. That's unlawful. And it needs to be addressed. So you can reference, fact check those details, and check if our conversation for today, whether I was just blabbing up and so on. But as you get into those meetings, you must know for a fact that you are going to a committee that is unlawfully constituted, and taxpayers' money is spent on a committee that is unlawfully constituted, and they'll be asking you things, to determine legal things when they cannot determine their legality themselves. So that's it. Judge it for yourself. And if there's anything you see there that is not like what I'm saying now, produce same documents. The CRL Act of 2002, that's my reference. Media statements, April 22nd, 2025 from CRL, and then October 6, 2025 from the CRL, legal services dated 9 December 2025. Those are major, references from where our conversation was based. And so, as somebody who's passionate about learning and bringing understanding, I saw it fit to share with you this so that nobody should say we did not know. We told it to that committee. They know that we told them that they are unlawfully placed there. And we have shown them through the Act, because the Act never said they are independent. If they say they are a Section 22, the Act says when commissioners are not there, it's not a lawful Section 22 committee. And again, the Act did not put a comma after the word staff on that provision of Section 22 committee. You see, and all those details that we spoke about, go through those things, find out for yourself, and verify what I'm saying. Yes, I know there's a case from the Muslim community, on challenging the Section 22 committee, and there's also a legal position by SACD, through the courts and so on. But I'm saying to you, the law will not change because of the courts, unless now the law is amended by competent, institutions that are given. And in terms of our constitution, the only institution that is empowered to change and amend laws is Parliament. Yes, the judiciary interprets. They interpret what Parliament has written in terms of the law and check if there's coherence in terms of constitutionality and things like that, so that we are fine and we become a nation that is governed by laws, not emotions, but by laws. Because if you are governed by emotions, there'll be a problem. So thank you for your time. I know you are enjoying these things, but take your time, pace yourself, check this out, fact check me. If this information I'm giving you is not like that, where there are errors, I'm more than able and willing. I'm that person who's not afraid of questions. Yeah, and then you may raise questions to say, but I read that thing, you told us that, it's not like that, and so on. If you are correct and I was in the wrong, I'll come on this platform like I am today to say I was in the wrong regarding this. Yeah, but where I stand with the available documents and so on, I've given you, I've referenced, taken the time. That's why I've been slow. And these things I'm sharing about, they are not what I'm saying this on the streets. That the very same things we've shared in Parliament, same thing that we have said them even to that committee, because it's a committee of leaders. We said, okay, for the benefit of a doubt, let's join them, tell them the truth. But if they reject this truth, whatever eventualities that will come up, the backlash that will come up with them, taking the money of the state for an unlawful activity. Yeah, they may come up and say, oh, but it was in good faith. How is it good faith? There's no good faith, because we are telling you, don't do this. We are showing you the law, and you ignore what the law is saying, and you are saying you are servicing us. And by the way, we have solutions as to what to do. And the solution is simple, and it has been proven multiple times that all that we need, the organs of the state, they just need to beef up. They need to implement the law, where there are criminalities and things like that. There's nothing further than that. Anything further than that, this exercise by the CRL will create a problem, a major problem. And then even if they can arrive at that the constitution will defeat. So it will be a waste of state resources. There's a lot that we can do with money. Even the CRL itself, is complaining about its own budgets and so on. So we can't afford to waste money when we need money, to develop this country and do other things. We can't just take money down the drain, and be excited and waste money. We must be good steward of the resources of this country as responsible citizens. Thank you for your time, family. Yeah, be blessed.